This landmark House of Lords decision, Hilton v. Barker Booth and Eastwood, remains indispensable for legal professionals. It rigorously defines solicitors, duties regarding client best interests, and conflict avoidance, serving as a critical case study for ethical practice and compliance. Mr. Hilton, a long-standing client, engaged Barker Booth and Eastwood, BBE, for a property purchase. Unbeknownst to Hilton, BBE also represented the vendor, Mr. Bromage, a known bankrupt and convicted fraudster. This dual representation created an inherent, undisclosed conflict of interest. BBE withheld critical information about Bromage, citing confidentiality, and failed to advise Hilton to seek independent counsel. Consequently, Hilton suffered significant financial loss when Bromage defaulted, exposing a profound breach of professional duty. Solicitors must not act for clients with separate, competing, and inconsistent interests. This objective standard dictates that if duties to one client clash with duties to another, a conflict exists, demanding immediate action. The House of Lords affirmed an inviolable duty of single-minded loyalty to each client. This mandates disclosing all material information relevant to a client's decision-making, a duty that cannot be diluted by implied contractual terms or convenience. A solicitor cannot leverage a self-created conflict as a defense for non-disclosure or breach of duty. Professional rules and client expectations supersede any implied terms that might otherwise limit fundamental duties of loyalty and disclosure. Acting for clients with potential conflicts is only permissible with full disclosure and genuinely informed consent. This principle, reinforced by cases like Clark-Boyce v. Muat, underscores the paramount importance of client understanding and autonomy. Hilton profoundly influenced the SRA Code, which now explicitly prohibits acting for multiple parties in conflicted transactions, save for strictly limited consented circumstances. Firms must implement robust systems to identify and manage conflicts proactively. Law firms must conduct mandatory pre-instruction conflict checks for all new matters. Obtaining explicit, written consent in potential conflict situations is crucial, alongside clear client communication regarding risks. Immediate cessation of representation is required if a conflict emerges. Hilton remains the leading authority on solicitors, duties concerning conflicts of interest, and client confidentiality. Its principles drive continuous improvements in law firm conflict checking systems, procedural formalization, and ongoing staff training. Hilton v. Barker Booth and Eastwood is more than a case study. It is a cornerstone of legal ethics and compliance. It unequivocally mandates undivided loyalty, transparent disclosure, and rigorous conflict avoidance. For every legal professional, understanding and internalizing these principles is not merely good practice, it is a fundamental obligation. We urge all law students, solicitors, and compliance officers to critically review their firm's conflict protocols and personal ethical frameworks. Engage in continuous professional development to ensure unwavering adherence to these vital standards, safeguarding client trust and professional integrity.